Good morning, everybody. Hello, my name is Larry Slavinsky. I'm a partner here at King & Spalding. I'm actually a member of the Board of Directors of the Georgia Justice Project, and I wanted to welcome everybody here this morning. We appreciate the big turnout that we have for this program. In terms of logistics, if you haven't found it yet, the restroom is down that way past the reception desk on the right. As you can see, we've got food for lunch and drinks as well. And again, very glad to have everybody here for this session, which I think is about a very important topic. I'm going to ask my partner, Lisa Keys, to get up and speak a little bit and also to introduce some of our speakers as well. Lisa has been involved directly with the Georgia Justice Project's work, and we'll talk a little bit about that this morning. And again, thank you for being here today. Lisa.
Thanks, Larry. So, true confession, I came to a program like this about 5 years ago because I needed CLE credit. It was March. The deadline is the end of March, as you know, in Georgia. I was desperate. I handle for the firm all of our training and development, so you can imagine if I were non-compliant with CLE, that wouldn't look good. So I got the credit, but I got so much more. So whatever your reason for being here today, even if you're like me, thank you. You'll definitely get CLE credit, but I think you'll find out so much more that will hopefully inspire you to take on some cases. Before I went to the training, I knew a criminal conviction could be a problem, an arrest record could be a problem, but I didn't really appreciate the gravity of it. And to learn that I could actually help take that monkey off people's backs was really inspiring to me. And that I could do it as a transactional lawyer. Heck, I was not a litigator, and so no litigation experience required, which I found really nice because a lot of projects are litigation-oriented and you feel like you need a lot of background. But given the support you get from the Justice Project, even a transactional lawyer can do it. So I was all in. I went to my first clinic, I think in like the month of May or June. I got not just one, but I got 2 clients. I don't know how they suckered me into that, but they did. You meet with them in person and you hear their stories and you hear how the record that they have has really impacted their life. And even if it has caused them, if they haven't lost employment because of it, they have this fear that they will not get employment if employers know about their records. So for both of the clients I had, what they wanted was better jobs. They had very specific jobs in mind, in fact. They didn't want to apply for those jobs, though, until they knew that their record was clear. So I used the Georgia Justice Project forms that are on the website, and you'll get books that have those. They download to Word. They're very easy to use. The trickiest thing I found was that the record restriction law is still somewhat new, and in various counties, they don't necessarily know how it works. And so you're doing a lot of navigating, and the Justice Project supports you on that. Sometimes you're educating the people in the county, though. Both cases that I first took were resolved successfully. Since then, I've done 3 other cases, and they've all been resolved by filings, by emails, phone calls. No hearings have been held. One was scheduled, and Brenda from the Justice Project went with me to it, but we ended up not having to do it. So I wanted to just close by telling you briefly about 2 of the clients, so you get a flavor of the type of people you'll get to meet. The first, Clarissa, was convicted of trespass and battery when she was living with her uncle when she was 16 or so. It was a really bad family situation. She then qualified to have that record restricted under the Youthful Offender Statute. She was holding off applying for her dream job at Emory Healthcare. Once her record was cleared, she got that job. Now, I have to say I haven't followed up in the last year or so, but I think she's still in it, so that's great news. Another really memorable client was Demira, who was a PhD candidate when I met her. When she was a high school student in Gwinnett County, she was at a bar that allowed minors to be there, but you had to wear a wristband to signify you were a minor and can't drink. A fight broke out. She was not involved in the fight, but the police came. They saw her with a drink and a wristband. She got arrested, misdemeanor conviction. Now, I don't know about all of you. I admit I drank when I was underage, but I never got caught. I was lucky. She was not lucky. She wanted to get a position as a researcher at a university when she finished her PhD, and she was worried the conviction would be an issue. So we got it restricted, and she's doing very well. So we know the clients are appreciative. It's not just the clients, though. One of our lawyers at KNS is handling a case right now in Gwinnett County. Her name is Nikki Bradley, and she got an email about a month ago from a DA in Gwinnett County. He said, "Additionally, thank you very much for taking on cases such as this through the Georgia Justice Project. I know being at King and Spalding, you have other things to do, and I'd just like to say it's very admirable to take on these issues, and I hope we can get it resolved quickly for all parties." So I hope you all take a case. The workload is manageable. I've found it to be 10 to 25 hours over a number of months. It's really easy. The forms are online. You get great advice, and you'll get much more than CLE credit. So thank you. And with that, I'm going to introduce Doug Amar. Doug is the executive director of the Georgia Justice Project. He really, you could say, almost started the Georgia Justice Project in a sense. Began volunteering there in 1986 and a staff lawyer in 1990, an executive director since 1995. He's, of course, a lawyer, a graduate of Washington Lee Law School. He's received a number of awards, as you could imagine, doing this excellent work from the Anti-Defamation League of the Southeast, UGA, Davidson, his college, and the Georgia Indigent Defense Council. It's fair to say he's dedicated his career to this cause, and for that we thank him, and I welcome Doug.
Thank you, Lisa. I'm really here just to welcome everybody and say a couple words, but I want to thank King and Spalding. Larry, thank you so much for agreeing to host us here today. I know we have folks who are not just K&S folks here, but I appreciate you all hosting. So for those who don't know, there's a long history with K&S in our organization. Our founder, again, I'm not the founder, but was a former King and Spalding lawyer back in the 70s and started this work in the 80s. So there's always been a connection to this institution and our institution, and I'm very appreciative of that. And it shows up in all kinds of ways. So, and this is just one of those continuing ways. I just thought I'm supposed to just say a couple words. I'm going to get a couple slides about who we are, because we have a lot of material to cover that Brenda and Aaron and Molly are going to cover. But I wanted to just give you a sense of who the organization is. And I should ask, I see a lot of familiar faces, some not. So how many people are familiar with us? I should ask, just want to ask. So about 2/3 of everybody knows who we are. So our organization is 33 years old this year. Let me go back. Is 33 years old. We're located in the old 4th Ward, right behind Dr. King's grave. Actually, we've been on that block for about 30 years. I always tell people that we're on sacred ground. If you stand at Dr. King's grave, you see the back of our building. It's an old gas station garage. It's been renovated a number of times. And I always say we're on sacred ground because we're lined up for justice right behind Dr. King. Our work really is 3 buckets. I'm a 3-bucket person. Everybody who knows me is 3 buckets. But our work is really 3 buckets of work. 2 of them are client-centric. 1 of them is policy and education. The thing we've done the longest is this holistic criminal defense work. And that's sort of our core sort of mission for about 20-some years. And by that, what I mean is that we take folks who cannot afford a lawyer. We don't charge our clients for any of our work, by the way. But we represent people, and what makes us different from a public defender or a private lawyer, for that matter, like Dave, is that we stay with our clients long term. We visit our folks in prison and work with our clients' families while they're in prison and help folks when they get out of prison. So this idea of rehabilitation and long-term reentry issues has always been core to our work, sort of grounded in that first bucket. The second bucket of work is I'm more and more calling reentry lawyering, but the biggest part of it, obviously, is our own criminal records. This is why we're here. And we work with folks all over the state, helping people overcome the impact of a record of a conviction or an arrest. And then the third bucket is really policy work. And that started about 11 or so years ago when we decided to go upstream in the battle and not just focus on direct service, but really try to change the laws that affect the millions of people in Georgia who have this issue. And I think you're going to cover some of those data points, right, Brenda? So I don't need to cover them. So those are, I would say, our 3 buckets of work. This is just a quick sense of some of our advocacy gains in the last few years. I think we've changed about 19 laws. And again, our focus has been on our policy side has been primarily on sort of reentry issues. And I know this point will be made, but I don't think you can hear it enough, is that 4.2 million folks in Georgia have a criminal record, about 40% of our population. About 25 to 30% of the American population have a criminal record. So there is a lot of folk out there who have had an engagement with the criminal justice system. And even if we decrease incarceration and decrease people under correctional control, there's still millions of folks out there who have had a brush with the law, whether it's last year or 40 years ago, that affects their lives. So that's why we have been really focused on making sure that the laws can change. And one of the things we learned kind of the hard way is that getting the laws changed was only part of the equation. I was pretty naive about it. I thought we got a law changed, go on to the next one. But if folks don't know about the law, if those implementing the law, judges, prosecutors, lawyers, police, and of course those who are directly affected and the nonprofits that work with them, if they don't know what the law is, then the law is not being effective obviously effectively used and engaged. So we do a lot of work around the state, presenting, training. I mean, this is one of them. We work with a number of entities around the state to do that. And this number has 75 plus a year. I think we're up to about 120 this fiscal year. Is that right, Brenda? So we do a lot of training to making sure that folks know about what the law is. And Lisa mentioned our manual, which is at the printer right now. There's up there on the. We do present a manual. We're on our 4th edition of criminal records manual. Yeah, that's right. Little hiccup, but we're at the printer. That will be in your hands very shortly. But we're on our 4th edition. All right. With that, I think I'm going to stop and turn it over. Am I done, Brenda? Is that all? Okay. So I'm turning it over to Aaron. Oh, that's true. We have. So we happened that we took advantage of your incredible graciousness and hospitality and brought our summer interns with us as well and some other staff. So now I'm going to put you on the spot. Would you all stand up for a second? Our law student interns, one of whom used to work here, so he should know most of the folks. Brian. But we're really pleased to have a wonderful array of summer interns from around the country, 2 of which are from Atlanta, but in law schools at Duke and up in Cornell. And then we have folks who've never been to Atlanta, coming from NYU and Yale, so we're very excited to have you all with us. And I think we have other staff with us who won't be introduced. Ann Carlton, who's our policy and outreach coordinator. So thank you all for being here. Thank you for letting us come. And with that, all the fun stops now because we're going to get right to the hard work. No, I'm serious. So thank you, Aaron. I'm going to introduce Aaron Donahue Keeler, who's our wonderful. She does many things. I can't say enough about what she does, but primarily focuses on our criminal records work. She's a former public defender for many years here in Fulton County and has come with us for the last year or 2 working at GJP. So we're happy to have you and happy to have you lead the charge here. Thank you. All right.
So I'm here to talk mostly about the big picture. This is our agenda for today. So we're going to get into what exactly the issue is, why criminal records are an issue, who criminal records affects, the collateral consequences. We'll talk then very specifically about the law regarding criminal records. What is a criminal record? How do you read one? What are the remedies for someone in Georgia who has a criminal record? And then, of course, we are going to try and solicit you to come and volunteer with us. We have 4 volunteer opportunities for attorneys and some for paralegals. Several places around the state have started doing record restriction summits, which are these wonderful events that community organizations or actually counties, DAs, prosecutors, clerk's offices put on. They invite people in the community to come, and on that day they will restrict their record, whatever's possible from that county. So we have been lucky to participate in many of these summits, and we would love to bring some volunteers with us to those. We also have our intake where we meet with applicants and advise them about criminal records and their criminal record, and then we review their applications and see if GJP can take them on as a client. And then you've heard a little bit about our clinic, but we have a monthly clinic where we pair attorneys with directly impacted people who have a criminal records legal issue, and we match them up to work on that issue together. And then we have many policy opportunities as well. We're more and more involved in that world. We've been doing it for at least a decade now, so there are some volunteer opportunities with our policy people too. So I think Molly's going to talk a little bit more about that at the end. So when we're talking about the criminal justice system, I think a lot of people picture people in jails or prisons across the country, but that is not the extent of the issue. As you can see here on this pie chart, so this is nationally, this is the U.S. justice system. There are 7 million people who are under correctional control. So that includes anyone who is incarcerated, on parole, or on probation. And as you can see, people who are incarcerated take up a little less than a third of this pie piece here. So really, when we're talking about this, the numbers are much bigger than just the people who are serving a sentence or waiting for trial. And here you can see this is Georgia. So in Georgia, we have 527,000 residents who are under correctional control. And as you can see in Georgia, many of those people are actually on probation. There's an even smaller percentage who are incarcerated, a small percentage who are on parole, and then probation is the majority of the people who are under correctional control. And I will say that all of these people, minus those who are involuntarily committed, which is just a small portion, and the youth, people in juvenile custody, all these people will have a criminal record. So this chart is super hard to read, but visually, I think it really hits home where Georgia falls nationally. So the blue section all the way on the left are people who are in state prison. The yellow is federal prison, then local jails, parole, and then at the end, the red section is the number of people on probation. So as you can see, Georgia is unfortunately leading the way in putting our citizens on probation. We put more people on probation for longer than any other state in the country. So who has a criminal record? It's estimated that total in the U.S., 70 million adults, that's 25% of the U.S. population, has a criminal record. And as Doug said, in Georgia, we have 4.2 million people. That's a lot of our citizens who have a criminal record. It's nearly 40% of adults. And this affects not just the adults who have a criminal record, but their families. And it's estimated that 50% of all children in the U.S. have a parent who has a criminal record. And studies have shown that criminal records can lead to collateral consequences. And when we're talking about collateral consequences, these are civil penalties that are a result of a touch with the criminal justice system. So these are not things that are part of the criminal system, part of something that the judge sentenced somebody to, but civil penalties. So these are barriers to employment, housing, professional licensing, voting, immigration. Almost all aspects of civil life can be affected by having a criminal record. There are over 47,000 laws and regulations in the U.S. relating to collateral consequences of having a record. So preventing people from obtaining certain professional licenses if you have a record or have a certain type of record. And this is sort of where GJP really got involved in this work. We, as Doug mentioned, we try and foster sort of a lifelong relationship with our clients. And when we were accompanying them on their journeys and they got out of prison, they were having a very difficult time getting employment. And statistics have shown that employment is the biggest factor when it comes to recidivism. If people can get out, get a job, and get back on their feet, they are much less likely to have another interaction with the criminal justice system. So again, we're talking about the effects of a record. So 50% of applicants with a criminal history are 50% less likely to be called back for an interview if they apply for a job. So having a criminal record means that qualified people are not considered for a job, or they're considered but not hired, or they're just discouraged from applying. They may not even submit an application because they believe that they won't have a shot at a job. And when we're talking about the criminal justice system in general, and also the effects of having a criminal history, we would be remiss if we didn't talk about race, because everyone knows, hopefully now, that the criminal justice system disparately impacts people of color in our country. Even without a conviction, people of color are much less likely to get a callback for a job. There have been studies done that have shown that a person of color, a black man who applies for a job without a criminal record is less likely to get a job than a white man with a criminal record. So race is inextricably tied into this issue. And the negative effect of a record they've shown is 40% greater for people of color. And of course, there's the economic impact of these policies on all of us. So of those collateral consequences, most of them have to do with employment. They've shown that $80 billion are lost annually because of the constraints placed on people with a criminal record. Formerly incarcerated men are 40%, get paid 40% less annually. And again, this is the statistic I mentioned earlier, that 50% of children have at least one parent with a criminal record. Upward mobility is diminished. The good news, this is where we come in, is that studies have also shown that earnings do go up after an expungement. So this can have an impact not only on an individual and their family, but also the community as a whole. And now I'm going to turn it over to Brenda. Brenda Smeaton is our legal director at the Georgia Justice Project, and she is our criminal records expert. So I'm going to let her get into the nitty-gritty.
Good morning, everyone. Feel free if you have, we're going to get into the nuts and bolts now. Feel free if you have questions, please raise your hand and let me know. Would much rather this be a little interactive than just me talking up here for the next hour or so. And then we will break in about 20 minutes and go ahead and grab our lunches and then come back. One thing, and either Doug or Aaron may have mentioned this, but I just want to reiterate, is that anybody who has ever been arrested for a fingerprintable offense has a criminal record. So a lot of times when we think about people with criminal record, we're thinking about just people that were convicted. But if you've had an interaction where you were taken into custody, then you have a criminal record. So, and last night I added a couple of extra slides, so they're not in your handouts. I decided not to kill any more trees than we already had. So there's just a couple of duplicate slides in here, but all the information that you have is in your slides, and I changed up in order a little bit. So hopefully that won't get confusing to follow along. But I did just want to start with the big picture. I think there's a lot of details about how the law works that we'll go into. And really, there are just 8 things that we can do to assist somebody with cleaning up their criminal record. And we usually ask our volunteers to assist with 7 of them. So, and I'm going to go back and explain what all these different terms mean and how exactly this works. But if people have non-convictions on their record, so they were arrested for something and it didn't result in a conviction, most likely they're going to be able to get that off through a process that's called restriction and sealing, which is something that most people know as expungement. So I'll sort of use the terms interchangeably. We don't call it expungement in Georgia because it implies that the records are destroyed, and that's not the case. It's just that access is restricted. Also, if people are sentenced as first offenders, has anybody ever heard of the First Offender Act before? This is Georgia's second chance law. If you've never had a felony and you've never used first offender, the judge at his or her discretion might decide to sentence you as a first offender. And if you successfully complete your sentence, then it's not considered a conviction. So we can get those off of people's records, and that's something we ask you to help with. If people have open cases, so not if they're still waiting to go to trial or something, but there's something called dead docket, where the prosecutor or the court will put the case on hold. Sometimes 10, 20 years later, that case is still on hold, and the prosecutor has no intention of coming back to open that up. We might be able to help people get those off. And for convictions. So we're starting to chip away a little bit at helping people get convictions off of their record, but it's still very limited in Georgia. As Doug mentioned, our policy work, we're one of only, it's always decreasing, so it might be lower now, but at least 38 other states, you can get a combination of misdemeanors and felonies off of your record after a certain period of time, and it's incredibly limited here. So what we can get off for convictions are youthful offenders, which are certain misdemeanors a person was convicted of before they turned 21. And sometimes we can go back. This was a change that we helped pass in the law in 2015, where a person didn't get that first offender, they didn't get that shot at a second chance when they were first sentenced. Sometimes we can go back and get that years later. So we've been working on a lot of those over the last 4 years, and that's something we frequently ask our volunteers to help with. And then the only other thing that you can do to sort of mitigate your record in Georgia is get a pardon, which doesn't remove something from your criminal record. It gives you a certificate of rehabilitation and a notation on your record, and it provides some negligent hiring and leasing protection for employers and landlords. But you've still got that conviction hanging out there. It doesn't make it go away. So those are the 7 things that we can do and that we ask our volunteers to help us with in helping to clean up our clients' records. And then also sometimes our clients' records are just wrong and we correct them, but usually we do that because that can be a bit of a nightmare to deal with. So Lisa gave a couple of examples. I just wanted to show you what a typical client might look like in the clinic. So let's say, take Joyce, for example, 68 years old and denied housing because of her record. And this is something that happens frequently. We see a lot of seniors who are being denied any kind of subsidized housing because of something that happened a long, long time ago on their record. So she was arrested twice, both in the mid-'80s. She had a drug charge that was dismissed, and then she had a felony drug charge that was a conviction. So she would be a good fit for our clinic. We would try to get that dismissed charge off because you can get most dismissed charges. And then she didn't get first offender, so we would try to go back and get retro first offender. So let's take Robert, another typical client. 24 years old, wants to go to college to be a nurse. A lot of times the hospitals, the different medical agencies won't let people complete an internship if they have anything on their criminal record. The healthcare, certainly there's good reasons for some stronger protections in the healthcare field, but sometimes it can go a little bit overboard. So he had 2 arrests. When he was 17, he was arrested for misdemeanor battery. He got into a fight at school, and he was convicted for that. And then in 2013, he had a misdemeanor marijuana possession that was dismissed. So for him, we could go back, we can get that dismissed misdemeanor off for the marijuana potentially. And for that 2012, since he was under 21, we could do a youthful offender. So those are just some examples of the kind of folks that we would assist and the different issues that we would ask you to assist with. And now I'm going to go ahead and get into the nuts and bolts of what that looks like. So when we're talking about a criminal record, we are talking about any information about the arrest and the detention of the individual, what they were charged with, which on the misdemeanor side in Georgia is called an accusation. On the felony side is called an indictment if they bring formal charges against you. What was the disposition of the case? The disposition is just the results of the case. Was it dismissed? Did it result in a conviction? Was it first offender? And how serious was it? Was it a misdemeanor, which is a crime that has a potential punishment of up to a year in Georgia? And then felonies, which have potential punishments from a year up to life. So what was the sentence? What did the court tell them they have to do? And then what did their supervision look like? And these are the kind of things that you're going to see on a criminal record. One important base bit of information to get about how criminal records work and how they show up is there are 2 different kinds of background reports that you have to deal with when you're out there looking for a job or a place to live. Or doing lots of other things in life, volunteering at your kid's school. I know that I had to go get an FBI background check to do that. So there are official reports, which in Georgia is called your GCIC. It stands for the Georgia Crime Information Center. It's a division of the GBI. It's the official law enforcement database. Every time somebody gets arrested, the police are entering information into this database. Courts, prosecutors, prisons, they're all entering information into this central repository, which usually people, the reports they generate, sometimes they're called rap sheets. Usually people just call them their GCIC report. So every state has one of these official databases, and they all feed into the national FBI database. So if you have to get an FBI background check, they're pulling from all these official sources. Anytime you've been arrested for something that was fingerprintable, it's going to show up in there. One thing to be aware of is that there's different levels of access to these reports. So remember when I said Georgia changed it, they don't call it expungement anymore, they call it restriction, and that's because what happens is access to that information is restricted to certain audiences. So law enforcement is always going to see everything, whether you get it expunged, whether you get first offender, you get it sealed, they can always see it. So they can see it, the prosecutors can see it in case they need that information to make decisions in the future. The individual, these letters here by these 4 different audiences for this information are something called purpose codes. You know, when you go pull a GCIC, you have access to a certain purpose code. An individual can pull a purpose code U so that they can see everything law enforcement is seeing on their record other than juvenile offenses. We do keep juvenile offenses pretty private in Georgia. The practice actually tends to be a little bit better than the law even. So an individual can't even pull those on themselves. And then non-law enforcement, so these are your employers, your housing providers, they can get access to your GCIC, and they're going to access what's called a purpose code E. So if we're able to get something restricted for a client or get their first offender discharged, it is not going to show up on that report. So they would not see that information at all, and they would not use it in their decision-making process. Now in Georgia, felony convictions are considered public record. So anybody, these other categories, you have to have somebody's consent to pull their record, but anybody can go onto the GCIC website and pull up an individual's Georgia felony convictions if they've got their full name and their date of birth. One thing to be aware of about these reports is that they're often missing information or have incorrect information. I see Shay shaking her head. Shay was with the clerk's office for a while. We know that about 30 to 40% of the results are missing in cases, so it might still look like a case is pending even though it's been closed out for a long time. So that's our official report. But the reports that actually get used the most often are private background check company reports. So most employers, if I go to apply for a job at Target or Walmart, they're not going to pull my GCIC. One, they want to be able to do it quickly and cheaply, and they also want to pull a national background check. They don't want to know just if I have something in Georgia. They want to know if there are other places I've lived and I have something. And very few employers can get access to the whole FBI database. There has to be special statutory permission for that. So they're going to pull a private background check report. I mean, I'm sure you've seen, you've either dealt with these reports or seen advertisements for them. Some of the bigger companies that you may have heard of, Higher Right, Sterling Info Systems, ADP, that are pulling these background check reports. And they are not pulling their data from GCIC. They are pulling it from all public sources of data around the country, clerk's offices and jails, arresting agencies, anywhere where they have public records, they are pulling that. A couple things to know about these reports. So they are regulated by the Fair Credit Reporting Act, so the same law that regulates people that are getting a credit report, a credit history for something. A lot of times, there's a couple of things to know about what the Fair Credit Reporting Act includes. One is you have a right to know if somebody's pulling your background, and you have a right to know if the reason that you're denied a job or a place to live is because of the information that they pull. They have to tell you under federal and state law that that's why you are being denied, and they have to tell you what it was on your background that was a problem. They have to tell you how to get in touch with the company that provided the information, and you have a right under the law to dispute that information if it's incorrect. So if I call up Higher Right and say, hey, you reported this felony conviction and I don't have a felony conviction or it's been sealed, then it becomes Higher Right's responsibility to check and see if they can verify that information. And if not, they have to take it out of their database and reissue a report to the employer. Another thing to be aware of, a lot of times people will say, why is something still showing up on my record? It's been on there for 7 years. There's sort of this urban legend that things fall off of your record in 7 years. That is not the case. I believe it was long ago, but for at least the last 20, 30 years, that has not been the case. So non-convictions cannot be reported by private companies after 7 years, but if you were convicted or it's still pending or anything like that, they can report it indefinitely under federal law. That doesn't mean that's what the employer is going to pull, particularly in this economy where employers are having to sort of broaden the range of backgrounds that they are going to check. They might say, hey, background check company, I only want to go back 10 years, or I only want to get felonies and not misdemeanors. But there's no limitation under Georgia law that says that they can't just go back as long as records exist. Also, these reports are often wrong. About 30 to 40% of the time, they'll have a serious error on them, so not just like a misspelling or something, but they will report convictions that do not belong to this individual. An example that I always give is I had a client, she had one misdemeanor theft by shoplifting when she was like 18, and we were able to get it off her record. She comes in about a year later, she had applied for a place to live, and the private background check company had said that she was a registered sex offender. And she had a very unusual name. Like, I don't think there were other people out there with this name, so it was just wrong. So we had to reach out to the company and get them to correct it. So that's something that happens pretty frequently, and more frequently if you do have a common name and there's other people out there that might have the same name and date of birth. Any questions about those two kinds of reports? All right, so the reason that it's really important to understand the distinction between those reports is that there's different ways that we have to deal with limiting access to the data for those reports. So all of our work usually starts with GCIC, with that official record, because of the way Georgia's law works. And Georgia's law is very different than most states. But in Georgia, you have to get something off of the official record before you can then get it sealed at the courthouse so that the private background check companies can't report it because it's no longer public record. So when we get something, we use the language restricted or discharged if we're talking about first offender. That means we are getting it off of somebody's GCIC report, but it's still available at the clerk. In most cases, this is an administrative process, and we'll talk more about the different ways that that can work. So once we get that done, then we have to get it sealed. Until 2013, you couldn't do this at all. So somebody could get something off of their GCIC, but then it was still available at the clerk, and the private background check companies could still report it. So now we have a process where if you get something off your GCIC, you can then petition the court to go ahead and seal those files so that it's no longer public record. And those do require a motion because those are always discretionary in Georgia. So I did want to show you, for folks that volunteer, we do always start with the official background, so you'll be looking at a lot of those. I wanted to show you a brief example, and this is something that GCIC actually provided for us to show folks of what information is on a GCIC report. So if you look at your handout, and I apologize, the writing is really small, but it says GCIC sample on it. You'll see on the first page, there's some disclaimers and whatnot. It says at the top what purpose code. So we see that this person, they were getting a purpose code E, so perhaps this was for an employer or a housing provider. You see any names that the person may have been booked under. Sometimes they're aliases, sometimes they're just misspellings, identifying information such as social security number. On the next page, physical identifying information and date of birth. And then below the dotted lines where it says, I'm actually going to skip over this part because GCIC has stopped providing that information there in the last couple of months. But so I'll just skip down here. Under where it says criminal record, it's always going to say at the top, cycle 1 of X. So in this instance, this individual has only been arrested one time, so they have cycle 1 of 1. It has the information, the first part will be the information about this arrest. So this person was arrested November 2002 by the Gilmer County Sheriff's Office, and they were charged with felony possession of methamphetamine. You can see down at the bottom that they were indicted, so the prosecutor brought formal charges against them. And then on the next page, we can see how this case was resolved. So in Gilmer County, this individual was convicted of a felony, and he received a split sentence. So that means he had to be confined in prison for 3 years to be followed by probation of 7 years, which would not be an unusual sentence in certain parts of Georgia, for sure. And also, the split sentences are somewhat unusual in Georgia. A lot of jurisdictions don't do that. They say, we're going to lock you up, and then we're still going to keep you under correctional control for quite a few years after that. And then down at the bottom of the report, we'll see information about all the different agencies that have come into contact with that individual. All right. So when you're looking at a report, we are looking to see how the different charges that an individual had were resolved. First, we're going to be looking for non-convictions. We know in most cases we can get those off. So what are the words that we're looking for to see those non-convictions? Not presented to the grand jury, might say NPGJ, means that they didn't, the prosecutor decided to not even try to bring formal charges against them. Or no bill, the prosecutor took it to a grand jury and the grand jury said, you know what, there's not enough information here. Null pros, Latin for not prosecuted, so the case was dismissed. It becomes an official dismissal in 6 months. Dismissal, of course, is clear. Dead docket, those are the ones that I mentioned that it's just on hold indefinitely until the court takes it off of hold. Acquittal, if you go to trial and you're found not guilty. Until 2013, you were still stuck with those on your record forever, but now we have a way that we can get them off. If you had first offender and you completed it, then it's not a conviction. And same thing with conditional discharge, which is sort of like first offender, but used for drug charges and property crimes related to drug use. So that's, when we see those terms, we are looking at non-convictions. When we see the terms on this slide, we are looking at convictions. And one that messes people up a lot is nolo contendere. We watch like cop shows or something and they say, I'm just going to plead nolo. And people think that that is not a conviction, but it is a conviction. I mean, it literally means I don't contest the charges against me. So a lot of what we do is just help people understand how to read their record. We do a lot of outreach with employers and talking to them about hiring people with criminal record, and a lot of them are telling us they're getting more open, but they're treating the background check as an honesty test. And if what the individual says about their record doesn't line up with what actually shows up, then they're going to say, we can't hire you because you lied on your application. But then people often don't understand what's on their record. They don't understand what nolo contendere means. They don't understand that if they got time served and they were let out of jail for 2 days, that still means that they were convicted of that. So a lot of times there's nothing that we can do under Georgia's limited law to clean up somebody's record, but we can at least help them understand it. If they had first offender and they were revoked, so say they got first offender and they got 2 years probation, but then they got convicted of something else and the judge said, I'm taking away your first offender status, then it becomes a conviction. Same thing with conditional discharge. So I did want to, I'm trying to figure out when is the best time to break. Maybe now? You guys want to take 5 minutes and grab your 5 to 7 minutes and grab your lunch, and then we'll come back and we'll take a look at a sample record that we've had in the office. All right, I'm going to go ahead and jump back in so we have enough time to make it through all of the material. But feel free, of course, to finish up your lunch as we go. So Derek's record, which says Derek Match, which you should all have a copy of with your packets. This is an example of course, not his real name, but this is a real GCIC from an individual that we assisted at one of the summits, one of the events that we've done. And his record is a little bit more extensive than somebody we might take through our clinic. We do have limited resources, so we have to turn away about 75% of the people that do apply for our assistance and try to use our resources where they're going to make the biggest difference for an individual, which sometimes means that they have less on their record, but sometimes people also have more extensive records, but they've got like one charge that's sort of an outlier or much more serious than the other charges. And sometimes we do assist people with pardons, so they might have an extensive history where they were addicted to drugs for many years and accumulated a long criminal history, but they've been in recovery for a number of years, and we can apply for a pardon for them. So it does vary, but this is an example of a little bit longer record. So if you go over to the second page, beneath the dotted lines where it says criminal history, below that you'll see that Derek has 10 cycles. So this is going to start out, and I'm just going to kind of walk through so you can get an example of, see what one of these actually looks like in real life. So if we flip on over to the next page, cycle 1, we'll see that in 1999, he was arrested for robbery. We look down below to see how that case was resolved, and we see that it was actually placed on the dead docket. So that case was put on hold, and at least according to his official record, was never resolved, even though it's over 20 years old. Then we go down to cycle 2, keep going down. We see that in 1999, he was arrested for financial transaction card fraud. 3 counts of it. If you flip on over to the next page, page 5, of felony. And we see, if we look below on cycle 2, that he actually got first offender for that. So he had never been convicted of a felony before, and the judge said, okay, I'm going to sentence you as a first offender. His sentence, if you look at the bottom of that page, was 2 years of probation. And it says that he successfully completed his first offender probation. So it is showing up on this record because if you remember from the front page, we are looking at a purpose code U. So this is his individual copy, which reflects everything that law enforcement could see other than anything juvenile. This is not a copy that we would give to an employer or a housing provider, but it's helpful for us to see what's fully on the record. So he had first offender, he successfully completed that, so that is not going to show up on his official record for employers. We keep scrolling down to cycle 3. We see that he was arrested for driving with a suspended license, and he pled nolo contendere to that, so he pled guilty to that. His next cycle, also a driving with suspended license, which is something that we see over and over and over again, that people have, I think Doug stepped out, but the number of people that are arrested for driving with a suspended license because, perhaps they haven't paid some sort of fee or traffic ticket or something like that. There's hundreds of thousands of those arrests around the country each year. So we go on over to cycle 5. If we keep going down, we see that he was arrested for theft by taking. It says severity unknown, which is common with theft charges. They might not know the value of the property there. So they're going to let the prosecutor determine whether or not that was a misdemeanor or felony. It goes down to aggravated assault and cruelty to children in the second degree it says misdemeanor in the description, and then it says severity felony. So we don't know whether that was a misdemeanor or a felony charge. That's something we would want to look at. And also just to, as an aside, we frequently get people that come in that have cruelty to children charges on their record in the second or third degree. And particularly in the third degree, what that means is that maybe mom and dad had an argument and the kids were in the back bedroom or they were in the house somewhere. And so the parents, if the children are present and even if they didn't hear anything or witness anything, then the parent is going to be charged with cruelty to children, which of course looks really bad on somebody's criminal record. He was also arrested for simple battery. So then we go down below to see how these charges were resolved. They decided the prosecutor said, we're not going to present this theft by taking to the grand jury. There's not enough evidence there. Same thing with the cruelty to children, but we're going to go ahead and indict. We're going to bring formal charges for that aggravated assault. So several counts, if you go on over to the next page of aggravated assault, were indicted. Sometimes if somebody gets in a fight, this means that multiple punches were thrown or something like that. So he was indicted for all of that. And if we look down to how that case was resolved, we will see that all of those charges were dead docketed. So again, that case was placed on hold. The prosecutor said, we don't want to pursue this at whatever time, but we're not going to dismiss it. We're going to just go ahead and place it on hold. So I won't go down through all of the rest of it, but he's got 4 more charges that are on here. Well, actually, I'll go ahead and do number 6. So we see that he was arrested March 17th, 2009 for simple assault and pointing or aiming a gun or pistol at another. You will see language by those charges that says time expired restricted. What that means is that nobody ever entered in a resolution to those charges. So I mentioned that GCIC was missing a lot of data, about 30 to 40% of the results. The dispositions in cases are not there. So when the legislature changed the law in 2013, they said that's not really fair to the individual. These charges are hanging out there because somebody didn't do their job of putting that data in there. So for misdemeanors, after 2 years, felonies 4 years, serious violent felonies, if no one's entered in the resolution of that case, we are going to restrict it from their official criminal record, and they call that time expired restriction. So on July 1st, 2013, I think it was like 5.4 million charges were automatically restricted. And every day that goes by, hundreds more that are getting to that 2, 4, 7 year mark, because those charges may have resulted in a conviction, but nobody ever entered in the data. So that's what time expired restriction means. And that means that I need more information to figure out how this case was actually resolved. Yes, Shay.
So on the time restricted, and the person running on purpose code EC?
No, so that's a good point. So Shay asked, so this is showing up here because I'm looking at a purpose code U. I'm looking at the individual or the attorney version of this person's record. If the reason that they did this is that if an employer or a housing provider pulls a purpose code E, non-law enforcement, that whole cycle, anything that says time expired next to it is not going to show up at all. So there is some benefit there because the employer is going to pull a record that looks shorter than the one that we're looking at. They're not going to see that completed first offender. They're not going to see anything that was time expired. But those information about that case may still be on file at the court. In the clerk's office, it might still be online. Some jurisdictions have their court records online. So it doesn't make the charge entirely go away, which is why we would do more research. Did you have another question?
The second question. Do you find that in different jurisdictions the dead docket means more than one thing?
Yeah, so the question was, does a dead docket, putting a case on hold, mean something different in different jurisdictions? So if you Google dead docket, it says a device commonly used in Fulton County. So it is under the law. Other jurisdictions can use it, but usually when most jurisdictions put something on the dead docket, they put it on hold. They're putting it on hold for a real reason. Then they have some intention of coming back. The reason might be that they can't find the individual or they can't find a witness or something like that. So it sort of stops the clock. There's no statute of limitations issue at that point because the person already has formal charges against them. But we're putting it on hold because we can't proceed. In Fulton County, they often put things on the dead docket in lieu of dismissing them. And frequently they'll say, we're going to put this on the dead docket and sentence you to some kind of diversion program, go complete anger management or something like that, and then your case will be dismissed. The problem is they never come back and dismiss the case. So it's just hanging out there. I've had to go back and get 35-year-old dead dockets off for somebody because it is a pending case. And if you're trying to get a job in a highly regulated industry, like one particular client I worked with was trying to get a job in a bank. And a bank under federal law cannot hire you if you have a pending case. Yes, it was a shoplifting from when you were 17 that was dead docketed, but it is still a pending case. Any other questions? So that is Derek's record. You'll see, if you scroll on down, or look down, there's a couple of other charges that he had. The next cycle, 2 of the charges were dismissed, and then he was convicted on a couple of them. and then a couple of other charges for driving with a suspended license where he was convicted. So what we do when we are reviewing a record, we want to go through 7 different steps to see what it is we can do. First, we want to look for non-convictions. Those are the things that we are pretty sure, with some exceptions, we can get off of somebody's record. And you think, well, why does it even matter to get a non-conviction off your record? If you arrested for something and you weren't convicted of it, is it really going to be a big deal? Employers do deny people jobs and opportunities based on something that did not result in a conviction. So they might look and say, hey, you were arrested for theft by taking. It was dismissed, but I don't know, maybe you did do something wrong and they just, you got off on a technicality, or they couldn't find enough evidence against you. So in some states, employers can't consider arrests that didn't lead to a conviction, but in Georgia, they can. So it is important that we go ahead and get those off. Even if an individual has convictions, if they've got a couple things that didn't result in a conviction that can come off, I'd much rather go in to talk to an employer with a short criminal history than a longer one. So anything that we can, we want to go ahead and get off. So we look for those non-convictions. We also look for any time expired restrictions, and we know that we need to do more research on those, whether it's looking online or going down to the courthouse to get information about that. Then we look for is this person eligible for a youthful offender conviction? Do they have something that they were convicted of before they turned 21, a misdemeanor? We might be able to get that off their record. And there are some limitations, which I'll go through. And then we want to look and see if they have a first offender, like Derek did on his record. Has it been officially discharged from his GCIC, so it's not going to show up on his official record? If so, does it need to be sealed down at the clerk's office so it's not going to show up on the private background check company's reports? We also want to look for mistakes, which is often something we don't know until we meet with the client and they say, hey, I have never even been in Milledgeville. I have no idea what this is. But we want to, when we talk to them, be aware of that. Then we want to look and see, are they eligible for retro first offender? So do they have a conviction on their record and they never used first offender? Up until 2015, people didn't have to be told about first offender. So unless they requested it or their attorney requested it, they wouldn't know to ask, and a judge wouldn't grant it if you didn't ask. So we might be able to go back. And if that's not a possibility, then the last thing that we want to look for people that have felony convictions, could we apply for a pardon for them? Have they been off? And I'll go into the specifics in a little bit more detail, but the main thing we're looking for is, do they have a felony conviction and have they been off paper so they completed up any sentence that they had, probation or parole, at least 5 years ago? So looking for non-convictions, just by way of review, all those different dispositions that I showed you on an earlier slide, we're looking for all those things where the charges did not result in a conviction, and most likely we're going to be able to get them off. The main law that we deal with is OCGA 35337, and you can see all of these different categories in there. A couple of them have an asterisk by them because there's a different process for those things. Most non-convictions we can get off through an administrative process, but some things we have to actually go to court and ask a judge to take off. So we're looking for those dispositions, those results that didn't result in a conviction. Not every charge that didn't result in a conviction can come off of somebody's record, though. So when we got the law changed, we were able to get the number of exceptions from 7 to 4, but we are still stuck with these 4. So I'm going to talk about the first one actually last. The other 3 don't come up that often, but say I got arrested for a drug charge and got a good attorney, they file a motion to suppress, it was an illegal search or something like that. And so the evidence gets thrown out and the case has to be dismissed because that was the only evidence against me. I'm stuck with that on my record for the rest of my life, even though the case was dismissed. So certainly for those of us that do defense work, that is unfortunate because you've gotten a good result for your client, but they're not going to be able to get it off their record. Other things was their case picked up in another jurisdiction. So say I got arrested for a drug charge in Fulton County and then the feds came in and picked it up or something and I was prosecuted for that. I wouldn't be able to get those Fulton County charges off. Or this has certainly never happened for one of our clients, but maybe one of your clients, if they had diplomatic or consular immunity or something like that, and that was the reason their case was dismissed, then it wouldn't be able to come off.
I have a question about that. If the feds pick it up and then the case is dismissed at the federal level, would they still be eligible to take it out of the state?
Yes, as long as the language could be less vague, but I would certainly argue that they were eligible because there's no underlying conviction. But I don't think the language is as clear as we would like it. Yeah. So the one that comes up the most often is if they pled guilty to other charges. So like on Derek's record, you remember I think it was cycle 7, he was indicted for 4 different charges, and 2 of them were dismissed, and then he pled guilty to 2 of them. That means that he cannot get any of that off of his record. So say I'm arrested for felony aggravated assault, a very serious charge, and then ultimately I plead to possession, or maybe I plead to disorderly conduct or something like that. Unfortunately, for my official record, it is still going to say that I was arrested for aggravated assault. So employers are going to see that serious felony on there. Certainly that is something we would like to change with the law, but that is what we are stuck with right now. So the next thing we want to do, of course, is look for those time expired, those charges where I can see the arrest and it says time expired, but I have no idea how it was resolved. I would look online to see if I could find that information. More and more jurisdictions are putting their information online, which of course has its upsides and downsides. And if it's not online, then I would need to go to the court where the case was resolved or likely resolved, or call them if it's something outside of Metro Atlanta and try to get those actual records to figure out how that was resolved. So youthful offenders, we ask our clinic volunteers to do a lot of these. These are you were convicted when you were under 21. I frequently use this little tool to figure out exactly how old people are, because sometimes the calculation doesn't work out well in my head. So they have to be convicted before they were 21, and they have to be off paper for 5 years. So say I was convicted when I was 17 and I had a year, because in Georgia, we are one of 3 states where you are considered an adult for criminal justice purposes when you were 17. So I was convicted at 17, I got a year of probation, and then I haven't been in any trouble. I wouldn't be able to get that off of my record until I was 23. So you've got to wait a good bit of time. But I've been off paper for 5 years. There are a number of excluded offenses that I can't get off, certain sex crimes, crimes against children. The only theft charges that we can get off are shoplifting and refund fraud, and serious traffic offenses are excluded. So the one that comes up most frequently is people will say, I'd really like to get that DUI that happened when I was 20 or something off of my record. We can't do it. DUI is excluded. So this is just a table that sort of lays it out in a different way of figuring out whether or not something is eligible to be restricted and sealed. So there's categories where if your case was resolved in that way, you can definitely get it off. If it was resolved early on, it wasn't prosecuted or no billed, then the prosecutor has no discretion to say we're not going to restrict that from your record. Conditional discharge, as long as it wasn't revoked. Accountability court, so say I was in drug court and my case was resolved that way and I successfully completed it, and at the end my case was dismissed, then I can get that off. There are many drug courts around the state that you still get convicted even if you complete the program, so those folks unfortunately are out of luck. So the things that I can usually get off are dismissed or null pros charges if none of those exceptions applies. And also acquittals. I can usually get those off unless there's any sort of evidence of jury tampering or something, which is going to be an unusual situation. The things that I can potentially get off that I have to go in front of a judge and ask the judge to approve are those youthful offender convictions, dead dockets, if my case was reversed or vacated and it's been at least 2 years since that happened. Say I had, if I have a fugitive from justice charge, say I was wanted on something in Alabama and they picked me up in Georgia and charged me with fugitive from justice, which of course sounds very dramatic on your record. And those are usually not prosecuted. You know, they'll send the person back to Alabama, or Alabama will say, we don't really want them. We don't care enough about this, whatever case it is, to come get them. But those will just be hanging out on somebody's record. So we can go in front of a judge and get those off. Or if the individual was convicted of a felony, charged with a felony, but convicted of an unrelated misdemeanor. And I'm not even going to talk about that one because in 6 years, we haven't had a single one of those. It's a pretty limited situation. So all those categories on the right are things that we often ask our volunteers to help with because they are discretionary. They do require filing a petition and potentially going to court. I would say 80% of the time, or even a little bit more, we don't actually have to go to court. We can get the prosecutor to sign off and consent, and then the judge will just sign it. But sometimes, depending on the jurisdiction and whether or not they've dealt with these issues before, we might have to have a hearing. All right, so one of the handouts that you have is a cheat sheet. On one side, it's just got sort of a table of eligibility of all the different ways that a case can be resolved and whether or not that's something we might be able to get off of somebody's record. So that's just a resource for you to have. And on the other side, it's got this table that kind of walks you through the expungement process, and I'll talk about that in a little bit. So the other thing we want to do is look for first offender, like Derek had first offender on his record. So first offender, just a little bit more about it. It's deferred adjudication. So you do say, you know, I'm guilty of these charges. You say you plead guilty, but what happens is that plea is sort of left hanging over your head. And as long as you successfully complete your sentence, then it goes away and it's not a conviction. If you mess up and you get convicted or something happens and the judge takes away your first offender, then that conviction comes down on your head and that's just a conviction for your record. So I mentioned, you know, no prior felonies. It can be either for a misdemeanor or a felony, but you can only use it once. There's quite a few charges that you cannot get first offender for, and I think I've got them listed on the next slide. So once you successfully complete your first offender, it's supposed to be taken off of your GCIC like it was for Derek. And then potentially now under the law, we could get it sealed as well. So we would want to check for him and see if his first offender case was actually sealed. The law does say that employers can't use these to deny somebody an employment opportunity, but there's also case law that says, but if they do, you have no claim against them. So that is not as useful as we would hope. Okay, maybe I don't have the first offender exceptions in there, but you can't get first offender for serious violent felonies, sex crimes, elder abuse. There's quite a long list of things that you cannot get first offender for, just so you're aware of that. DUI is one of them. So just to go back and look at Derek's record and see what potential remedies for him might be. So for that robbery that was dead docketed, we might be able to get that restricted and sealed because it was a dead docket. We would have to actually file something. For his first offender, cycle 2, we know it was already removed from his GCIC. We were just seeing it because we were looking at his personal copy, but it might need to be sealed at the clerk's office. The next couple charges down, he pled nolo and then he was convicted. There's nothing under the current law that we can do about those, no matter how old they are. Number 5, the theft by taking an aggravated assault, so certainly some very serious charges. Those were dead docketed as well, and that was, you know, a number of years ago. It doesn't appear that the prosecutor is going to pick that back up, so we would want to file something to restrict and seal that. The simple assault, we need to do some more research and figure out how that case was resolved. And then as we go down, you know, there were cases where he was convicted of some of the charges, even though some of the charges in the cycles were dismissed. And that means we're not going to be able to do anything under the current law for any of that information.
Say all that again.
Yeah, so number 7, so...
My question is, so you plead guilty to half the charges, which is every plea bargain out there.
Yeah.
So it's irrelevant whether your charges are dismissed or...
So for GCIC, if you had formal charges, so say he had formal charges for all 4 of these things, And then he pled guilty to a couple of them. That means that none of that can come off of his GCIC record. In our experience, so remember how I said the private background check companies can only report non-convictions for 7 years. So after 7 years, they're not going to report that DUI or the willful obstruction. But in the meantime, in that 7 years, there's nothing I can do about getting those off or sealed. Did that answer your question? It's not going to change, but yeah, it's unfortunate because the way that the system works is that they arrest you for the most serious thing that they can possibly make a case or supposedly make a case that you are guilty of, and then send it to the prosecutor. The prosecutor might charge you with something very serious in an effort to get you to plead guilty. You may know that about 97% of cases in this country are resolved with plea agreements. Not that many people are going to trial, and you can be threatened with a longer sentence if you do decide to exercise your right to have a trial. So there's a lot of pressure to plead guilty, and so they'll often knock those charges down. So you end up kind of stuck under the current law with that more serious stuff on your record.
One more thing about that is we have had luck with a few counties where our client has been arrested for something, but then it's been pled down to a city code ordinance violation, and we have had success with getting those restricted. So it's not exactly Derek's situation, but where they end up pleading to disorderly conduct, which is a Clayton County code ordinance violation, non-fingerprintable.
Yeah. And that's something we hope to change with the law, because technically an ordinance violation is not a conviction under the law. So our argument is that there's no conviction there, and GCIC will go ahead and expunge those. So the other thing we look at, and someone has some questions about this, is whether or not there's a mistake on the record. Sometimes people will say, I was never even arrested for that. So we have a process that we send them where they go get their fingerprints done, and they're compared to the fingerprints on file for the arrest. Sometimes there's just wrong information on the record. So we would go back to the agency, say, the example I always give is I had a client that was arrested for driving with a suspended license. They keyed in the offense code wrong, and it said felony possession of bomb-making supplies. So that was the wrong information on his record. We were able to get a copy of the police report and then get that corrected. Another more vague category is, I never should have been charged with that. There really wasn't enough evidence to support those charges. And that is found in a section of the law where you can challenge something if you find it to be misleading or inaccurate. So that is a possibility, less likely to be able to proceed with that, but there is some room for argument there. So, like I mentioned, retro first offender, this is our first way. We're excited to be able to deal with some convictions finally. So say, Derek had never received first offender, he wasn't told about it, we might be able to go back and get him first offender. That was the only felony on his record. So he hadn't been convicted of a felony before that. He wasn't told about it, and it was an eligible offense. So from my perspective, the problem with this law is that it is written so that you cannot file something, you cannot get in front of a judge unless the prosecutor says it's okay. So we have to call the prosecutor and explain the situation. Sometimes we draft the motion, we make the case about whatever our client's situation is and tell their story about how it's a barrier to them and say, will you give me permission to file this? And then we get in front of a judge, and then ultimately it's the judge's decision of whether or not they're going to give them retroactive first offender. And it's a very vague test, says the ends of justice and the welfare of society are served by giving this person first offender. So, yeah, it doesn't matter how long ago it was. If they were eligible at the time for first offender, then you can go back and ask. One complication is that, say the person got probation violations or sort of messed up. Generally, prosecutors won't give first offender if the person would not have successfully completed first offender back if they had gotten it at the beginning. Here are those exclusions. So just a list of the crimes that you can't get first offender for. So if none of those are an option, then we are left with pardons. And pardons, there's a lot of debate on how useful they are because they don't remove anything from your criminal record. They just give you that certificate of rehabilitation. Like I said, we have been able to get some improvements in the law where now if an individual has a pardon and they apply for a job and they present that pardon to the employer, it provides some negligent hiring protection for the employer. It creates a presumption of due diligence, and it does the same thing in the housing context. A lot of employers don't know about that. We would have loved to get a bar on liability. That's what some of our business partners wanted, but we were able to get that presumption. So it's an order of official forgiveness. They're issued by the State Board of Pardons and Paroles in Georgia, not by the governor. And they're generally for Georgia convictions only, though sometimes if you're trying to get a firearm, you can get one for an out-of-state conviction. So there's a couple of different kinds of pardons. One, you can get your civil and political rights restored 2 years after you're off paper, so you're not on probation or parole. It doesn't get you a lot. You can serve on a jury, you can be a notary, and you can run for office. But it's kind of a lot of work to go through unless you really love jury duty. Most folks want to wait for the general pardon, which is something that you can get 5 years after you're off paper. The guidelines say that you have to have lived a law-abiding life in those 5 years, so you can't have any pending charges, fines, or outstanding restoration. You can also, at that same time period, apply to have your firearms rights restored, so anybody that's convicted of a felony loses their right to carry or possess a firearm in Georgia. There's some additional requirements there, and you have to have an interview. And then if you had an offense that required you to register as a sex offender, 10 years after you were off paper, you can apply. And that was I think that was a 2015 change in the law. And to our knowledge, not a single one of those has been granted yet. So voting, one thing, as much as possible, we try to spread the word whenever we're speaking around the state about what it means for voting when you have a criminal record, and something, when you meet with people and consult with them about their record, we want to make sure they understand. In Georgia, our law is not terrible. The law is not terrible. Kind of how it works out in practice is a little bit terrible. But what it says is that people who are currently serving a felony sentence cannot vote. As soon as you are off paper, then you can vote. So you're off probation, you're off parole, then you just have to register to vote. So the problem with this, it goes back to that table that Aaron showed you with that big line across with all the people on probation. So in a lot of states where they might even limit probation to 2 years, it is not unusual for us to see 15, 20-year probation sentences, particularly out of South Georgia. So usually those folks don't even have to report. They don't have to do anything, but technically they're still on paper for that 20 years, and they would not be able to vote. But as soon as they are off paper, they can register. So just want to talk a little bit about process, and I will tell you that if you decide to volunteer with us, and we are going to get you all the hot off the press manual in just a couple of days. They're probably arriving at my office right now. But when you volunteer, we will provide you with checklists for each individual category. If you've got a youthful offender, these are the 8 steps you need to take to do a youthful offender. So if you get to the next 10 minutes and are like, I don't think I can do that, that is okay, because we're going to walk you through it. So for restriction, that thing where we can get something off of somebody's GCIC, I mentioned that usually that's sort of an administrative process. The process is a little bit different depending on when you were arrested. If you were arrested before July 1st, 2013, which is when we got the last major rewrite of the law, you have to fill out this application. We fill out the first page with our client, which just has identifying information, what the date of the arrest was, what they were arrested for, and we send it to the agency that arrested them. with whatever else that agency requires. They may require a certified copy of the disposition in the case. They may require a $25 or $50 money order to process the application and a copy of the person's driver's license. The police, the arresting agency fills out Section 2 and they send it on to the prosecutor, and the prosecutor is the one that ultimately says whether or not it's eligible. And they can't just say, I don't like this person, I don't like this charge. They have to consider the criteria in the law. So we get that back, say our application is approved, then we could, it comes off of the GCIC and we can file a motion to seal so that the clerk's file is no longer available and the private companies can't get it. There's also a way under the new law to get the jail records sealed, which is just sending a letter, which we have a template for. And we utilize a clearinghouse. There are several of these around the country, but one of the problems with getting something sealed is that data has already been out there. So say I got retro first offender for my old drug charge, but for 20 years, these private companies have had it in their database that I have a felony conviction for drug possession. So several clearinghouses have come together, and private background check companies are members of them. We send the order to them, and then they send it to their member companies to try to reduce the chance that is going to pop up at a later time. So if they are arrested after July 1st, they don't have to deal with that application. What's supposed to happen, but doesn't always happen, is as soon as the case is resolved in a way that's eligible, so say I had a drug charge and it was dismissed, it should be restricted from my GCIC report at the time that the dismissal is entered by the clerk. So the prosecutor should say, this is eligible for restriction. They should indicate that on the disposition, and the clerk should enter that. Often what happens is that the prosecutor does not say whether or not it's eligible, and the clerk can't make that legal determination, so it doesn't get restricted. So sometimes we have to go hound the prosecutors a little bit to make that happen. And then once we're sure that it is off the GCIC, then we would file the motion to seal and go through the rest of the steps. So the part of the process where we ask our volunteers to step in the most is, because it does require filing something, is more around sealing the clerk's file. So after it's off of their GCIC, we would file a motion in the court that handled the charge, send a notice to the clerk and the prosecutor. And what we have to show is that, one, that it's been restricted, so it's not on their GCIC, and second, that the harm to the individual outweighs the public's interest in the record. So we have to meet this balancing test, and I think it says clearly outweighs, actually. So what we need you to do is to tell our client's story. How has this record been a barrier to them? What are they trying to do? Are they trying to feed and take care of their kids? Are they trying to get into school? Are they trying to get a better job than the one they have? Anything that we can put on our side of those scales to tip it in our client's favor. One thing that has been an issue, and we've had to do some appellate work around, is that some judges around the state will say, I always think it's in the public's interest to have these records be available. And we were able to get a good decision last year on that, where the court said, you know what, the prosecutor has to have something specific, some specific harm about this person's record not being available. Not just, I don't think records should be, I think they should always be available. That's not sufficient. So we're still doing some education around that, and probably some more appellate work around that. So like I said, tell your client's story. In our initial interview, we try to get as much information as we can about our client and what's going on with them and what they're trying to do. So yeah, this is basically that process that I was talking about. We meet with them, we get any documents that they may have. Sometimes we have to follow up and get additional documents, put together their story and file the petition. One helpful hint, we never want to attach our client's criminal history, because then we've just made their criminal history public record to everybody. So we've had to go back and amend filings and stuff like that. So we never want to do that. And then we usually reach out to the prosecutor and say, will you consent to this? And for retro, we have to do that before we file it. Like I said, there may be a hearing, but in most cases there is not. I guess we do have a couple of minutes for a hypo. Where's Molly? Are we good with time? Okay. All right. So just to give you a couple of examples, so let's say Lurleen was arrested in 2005, and it's the only arrest on her record. She was charged with felony aggravated assault. It was amended, and she was ultimately convicted of misdemeanor simple battery. So can we get that felony aggravated assault charge off of her record or the misdemeanor simple battery? Anyone want to take a guess? Yeah.
Can if you do a retro first offender. I'm guessing that's probably the only way, or a retro. I would say retro first offender is probably the only way to do that.
Right, because she did plead guilty to something, so we can't even get that aggravated assault charge. So she's not eligible for restriction. But if she was under 19, maybe we could get youthful offender. And if she was, she was 30, but she'd never used first offender, then we could get that retro first offender, potentially. Just one more example. So let's say Jim has 2 arrests on his record. In 1999, when he was 19, he was arrested for a misdemeanor marijuana charge and pled guilty. And then in 2000, he was arrested for felony theft by taking, and he was convicted of that. Anyone want to take a stab at what we might be able to do for him? Right. Go for it.
If you could go back and get conditional discharge on marijuana, potentially, or youthful offender.
Exactly. Yeah. And if we couldn't get the prosecutor to agree to the retro, then we might be able to, then we would be stuck with a pardon as our only option. So just to give you an example, let's say he had 2 additional arrests in 2017 and 18 and they were dismissed. That would take him out of the running for a pardon. So then it would make it both less likely that we would get a retro first offender because he's had 2 recent arrests. We could still potentially try, and it would take him out of the running for a pardon because he's got those recent arrests. I am going to turn it over to Molly to talk to you about the different ways that you can be involved.
Hello, my name is Molly Scott, and I am the Legal Volunteer Coordinator and Staff Attorney at the Georgia Justice Project. And we have several volunteer opportunities, mostly for lawyers. A few of these we are able to use paralegals. So the main one is our Criminal Records Clinic. It is coming up on our 5th year anniversary of the clinic, and the clinic is held the second Friday morning of each month. And at the clinic, we have about 5 to 7 attorneys and about that same number of clients. And we pair up the client with the volunteer lawyer and have you go through their record. And the key point at that meeting, that interview, is finding out how their record has been a barrier. Is it employment? Is it housing? Is it licensing? How can you flesh that out in a petition? And with the clinic, since it may be a couple months from now, maybe even longer than that you come and volunteer with us for the first time, we do a brief refresher training with just the lawyers at the outset of the clinic. And then we go through each file. Specifically, Erin and I are there to answer any questions. And we also, going forward, provide those templates for your specific petition. So if you were assigned a youthful offender case, we would then provide you with the template for youthful offender petition so that you do not have to reinvent the wheel. And we do as much hand-holding or as much you go and do it on your own as you would like. We do have those manuals, our 4th edition, coming out any moment now, and I will be in the next week or so either delivering it to you or putting it in the mail to you. So that will also provide the template motions and other helpful guidance. I did list our upcoming clinic dates.
up on the last bullet point. And I will, once I finish with the volunteer opportunities, I will be out at the table where you signed in for CLE credit. And if you would like to sign up for the clinic or for any of the other volunteer opportunities I will discuss in a minute, we'd love to have you do that. And, I think it was Lisa Keys who spoke at the beginning about her experience. She's a corporate lawyer. We have brand new associates volunteer with us. We have lawyers that are retired from their law firms. We have in-house counsel, corporate, we have litigation associates. We have everything under the sun, real estate attorneys. So we do try to make it as simple and straightforward with checklists and the template motions. Another volunteer opportunity is intake as well as First Fridays. So intake we do in our office, and the clinic is also in our office in the Old Fourth Ward. Intake occurs every Thursday morning, and that's when we have a handful of potential clients that we have come in and we sit down with them, review their GCIC, find out some more information about their situation so that we can then take that file, that potential file, to our client services meeting and see if we can take them on as a client. Then the first Friday happens in our office the first Friday morning of each month. That is when directly impacted individuals can come to our office, hear a presentation from a lawyer or our paralegal about the criminal records law in Georgia, what qualifies, what doesn't qualify. And at the end of that presentation, we break into smaller meetings with just the lawyer and the client, or our paralegal and the potential client, to get more information from them. So we love to have volunteer lawyers and paralegals help with those opportunities. And we'll have sign-up lists out there as well for those. Then the record restriction summits have become a big thing. I know, for instance, like Veterans Day coming up in November, it's Fulton County DA and Solicitor's Office are having one. Okay, at least the solicitor. But they happen all around the state of Georgia. Often, sometimes they're on Saturdays, sometimes they're on holidays. But we are there to provide assistance. We are there we sometimes get clients from those events where they had situations that they couldn't be assisted with that day, but we feel like we can assist them moving forward. So we love to have volunteers help there. And then also we have these various career fairs and service provider events that we help out with. Metro Reentry Facility, this you may have seen emails about a separate CLE that we put on last month about this. This is a new rehabilitative prison in DeKalb County. We assist returning citizens there with reentry issues involving, resolving criminal detainers upon release, the failures to appear, reducing child support arrears, and assisting with some release date matters. There are opportunities there for what we call intake at the facility, and then also more full representation volunteer opportunities. If that's something that interests you, I can certainly put you in touch with Cindy Chin in our office, who manages that program. And lastly, we just want to get the word out. We are so glad that you're here to learn about this issue in Georgia, because it is so important and it impacts all of us, no matter whether you have a criminal history, whether somebody in your family does, but all the economic ramifications and everything else. And we really are trying hard to spread the word within the state and increase our policy efforts so that we are able to move towards what most other states do have, where you can restrict and seal some convictions under limited situations. So if you would like to help out, we participate in a lobby day at the state capitol. That'll be early 2020. But even on a smaller scale, you might be at a cocktail party this weekend with a legislator, or you may have a neighbor or a friend, and just talk about this issue with your friends, your colleagues, your family. If you would like to get more involved with contacting legislators, we certainly would love to have your assistance, because the more knowledge that's out there, the better we think things will move. With that said, Aaron and I, and our contact information is on the last slide. Please feel free to reach out to us with any questions. Certainly, if you don't know your calendar but would like to sign up for a volunteer opportunity in the future, let us know that. And I do have a few housekeeping words. If you didn't sign up at this front table right outside the door for CLE credit at the beginning, please do that. We'll be submitting that in the next week or two. And if you have not paid, we will accept payment as well. I will get you those manuals as soon as possible. And in your packet of handouts is a survey. Please fill that out, and you can also return that to the table out front. We love to hear what works, what doesn't work, what we can do to improve it going forward. And thank you, Larry. Thank you, King and Spalding. We really appreciate you hosting us, and we appreciate all of you coming. So thank you. Does anybody have any questions before we break up? Okay. Thank you very much.